I'm already writing it.
All right, we call two cases, 19-33628 and 33629, the state of Texas versus Raymond Peoples, who is present. Mr. Peoples, as I recall in our last hearing, you insisted on representing yourself.
Yes.
And that's still what you want to do.
Yes, Your
All
Honor.
right. Again, I will repeat the difficulties of self-representation, doing this for 43 years. It's I can't recall a successful attempt at doing that in trial, especially a trial of this nature of a first-degree felony. You certainly, though, are allowed to make a voluntary and knowledgeable decision on your own life on whether you want to represent yourself or not. The court, even though you want to represent yourself, I think Mr. Aldwin Samuel was last. I'm going to ask him to, as we go to trial on these cases, to be close by. If you change your mind at any time to wish to either get him as your lawyer or ask him some advice on some legal matters that you might be concerned about, whether you are making the right decision, or you might be confused about legal matters, then he'll be available close by that you can seek his help at any time. Okay, just know that there's a lifeline. So why are we here today? Go ahead.
Oh, well, for starters, Samuel continue refusing to give me any of the paperwork that I'm asking for that you ordered him to do so.
Like what?
The probable cause affidavit, the affidavit to the witnesses, the police report, the affidavit, I mean the indictment itself, because the captains at the jail keep taking my paperwork. That's why I got it all with me now, because I'm trying to avoid that again.
Okay.
We're not
Okay. Are those things y'all can make a copy of to give to him?
You want the office?
Wait, go over what it is that you need.
the paperwork that my wife gave him also.
What is that? I would know
They
that.
have all the evidence that that is necessary for this trial or whatnot to prove everything.
We're going to need I'm going to need Mr. Samuel to get with him about all of this, because
He got the
he's
search
not here.
warrant. He got the search warrant from my phone, my car, my DNA, and my wife gave him the Facebook comments and the conversation between the victim.
I'll ask him to make a copy of that all that information is filed, and let me talk to him if that's a problem, and I'll direct him to do that, and then get it over to Mr. Peoples as soon as we can.
And
What
I'll call his office today.
as far as legal advice, his competency is. Let me say this. I said to the man, I need the witness probable cause affidavit. I mean, the witness affidavit. He said, I'm not allowed to have it. I say they already testified, so it's public information. He said, no, it is not. That doesn't make it public information.
I'll order him to give it to you.
What legal wise, the man is incompetent.
All right, what is the Supreme Court has already ruled on that until the
You wouldn't
the
be
bar-
able to have another.
Are you going to
Oh,
interrupt?
sorry, excuse me.
Until the Bar Association and the judicial system in the state of Texas deems him otherwise, defendants, you can have your opinion, but your opinion is not going to override the fact that he is considered competent. He's passed the bar. He has not been deemed incompetent by an authority until such time you're entitled to your opinion.
Is it
But-
any way that you can force a different attorney on me instead of
No.
him?
No, he is, the problem is he's the one who came up in the random movement, the selection. And indigent defendants, we can't jump over the line.
Well-
Every person that is an indigent defense lawyer is in the line, and if you skip the line over, you have to have good cause to do that. And the indigent commission comes and reviews all of that every 2 years.
And that's why I asked to be pro se, no lawyer at all.
Yeah, well, you can continue to do that, but we're going to have somebody close by available if you change your mind.
But could it be a different lawyer?
No, sir. It's going to be whoever is up next in the indigent law, under the indigent law. He's in the indigent list. He's the one who came up, right? He was the next one.
Yes.
And that's
He's working with the DA against me.
what's next.
It impairs my ability to prove my innocence with him concealing all the evidence that I'm allowed to have and all the paperwork that I have
He's
a
gonna,
right
he's
to.
gonna be ordered to provide the paperwork you're requesting.
You ordered that 2 months ago. And
I'm
he still haven't
I'm
gave it
gonna
to
find out what's delayed it,
me.
because I'm pretty, um, when I have to pick up the phone, lawyers know that they've got just minutes to fix it, not days.
Yes, sir. One more matter, I've been trying, I sent 2 applications for subpoenas or whatnot recently, and the clerk continued refusing to file it or
Why,
present it to you.
why are they continuing to refuse that?
Because they say they're not allowed, that the judge don't issue subpoenas and they're not allowed to issue subpoenas and all of that. And I was trying to explain to them, the law says otherwise, and they said, well, we don't issue subpoenas for defendants here or whatnot. So,
Well, when you represent yourself, as long as you are applying for a subpoena the way a lawyer would apply properly, you are entitled to have your subpoena enforced, as long as you're doing it correctly.
is it okay if you inform her that so she can stop?
Yeah, it's at the district clerk's office, and I can find out what that is. It's just unusual when people represent themselves, so they don't have to deal with that often. And I'm sure they get worried about whether, since it's something that is unique, that they're doing it right or not. So you're entitled, as long as you're applying correctly, you're entitled to have a subpoena.
Yes, sir.
Then but just do it correctly. If you don't do it correctly, I can't help you do it right.
Understood.
You know, yeah, but as long as you're doing it right, it will be processed as you would for any licensed attorney representing a defendant. Yeah.
The manner and selection of the computerized jury or whatnot, when would that be?
It comes up on the day of the trial. That's how
Okay.
we get the list.
Okay,
That's what we learn about it on that day, and that's what we do voir dire about.
okay. Most definitely. All right, well, my issues is come to a final.
Oh, okay, all right. We can get, I'll work on that immediately and try to get this resolved. When did we tentatively set
May
this?
15th. I'll,
We have a
today I'll make sure it gets, I'm fixing, you'll get the indictment and the probable cause up printer, so you can at least have that.
Also, wanted to view the witness videos, the witness as they, because on the search warrant, he said it was video statements from the witnesses. or
Mr.
whatnot.
Samuel has a-
Yeah,
he's
All right,
providing copies of this,
yeah.
so you can show them to him if you order him to.
Yeah, okay, anything he has that was not his work product that you are allowed to have as discovery, I will order him to get it to you.
for sure.
He'll get those copies of that. What else? Is there anything else? Oh, on that setting for trial, the week before that, we have a trial that's specially set. That's a very old, I think it's the oldest oldest case in the county. And it may take more than a week. So, but everything will stay in its order. It'll, if it's not that following week, it'll be close to it. It'll just have to, we'll have to wait for that trial, which I've heard has a lot of DNA analysis, and which tends to slow down a trial.
Is this,
What is that you gave him?
The probable cause in the indictment of the case we're trying. That's,
Okay,
oh, it's only one probable cause?
yeah, there's just one probable cause. It has all the facts in it, but it'll provide all of them. So. But Mr. Samuel has the rest of the discovery. If he doesn't provide it, Judge, then court can let me know and we'll figure it out.
I also wanted all the evidence admitted in the, I was wondering if we can get a consolidation on the 33629 and the 33628 to be conducted, since it's rising out of the same kind of circumstances or whatnot. If we can get a consolidation for it to be conducted at the same time.
stand by.
There are two separate.
Yeah, there's two separate dates.
Yeah, but you know, no, okay.
But that doesn't mean that the evidence of one may be allowed, admitted for the other, for other purposes that the rules of evidence allow.
Yeah, but is it possible I can have the other two from the other two cases testify also, like questioning, examining me at that trial?
For what purpose? Well, I mean, if you have a lawful reason under the rules of evidence
Yeah,
that you can convince the court, because I was on the rules of evidence committee that wrote that.
right.
See, so we're going to follow the rules as I helped compile them,
So,
but a case generally sits on its four corners of its allegations, each case.
so
And you generally do not try more than one case because you've got the possibility that the evidence of one case could pour over in the deliberations in the jury to the other case. They can get confused, and before you know it, they're using evidence that was supposed to be pigeonholed for one case into another case. And that's hard to fix. So we generally try allegations. There are very few exceptions. When an indictment has a different date, even if it's the same type of crime, if it's a different date, then it is a separate event. It stands on its own. But circumstances could be such under the rules of evidence where evidence that would be allowed, be relevant in indictment number 2 could be admitted in indictment trial number 1 for certain reasons.
so
But the court has to hear those, and then I'll make a ruling, and then I make findings.
all three cases on the same probable cause affidavit in the same search warrant probable, and it arising out of the same circumstances in
They can put more than one crime in one probable cause affidavit.
I know that's but what I'm saying is arising out, the way they did it is arising out of the same
That's
scheme,
what the police did.
right? And it was a lot of aggravated perjury, subordination of perjury, and tampering with witness. And
Well,
the other two is the way he collaborated, all three.
who?
The Detective Charles Duchamp,
Oh.
the way he collaborated all three, it was rising. He put it in a form as it rising out of the same scheme and the same plan, you know, and the fact that, you know, it aggravated when they testified, it was a bunch of aggravated, obvious, self-explanatory aggravated perjury dealing with it.
You got the way an investigator may write a report is not necessarily the way a grand jury elects to indict. They didn't indict the way you're talking about. They indicted two separate indictments, and they don't claim in the four corners of the indictment that they were part of a common scheme. So that's what all we can do is what was formally, The police don't decide what charges are going to be filed formally by a grand jury. The grand jury decides after listening to evidence. Police have recommendations, but it's an independent body that indicts, and how they indict is what we go from. It's like the map that we're not going to use Duchamp's map. We're using the map that was made by and voted on by the grand jury in the four corners of the indictment.
Yeah, and Penal Code 2.03 explains that actually is able to be done like at the judge's discretion.
It's not going to be done.
Okay. Yes.
It's
Yeah,
each rides on its four corners. But evidence that may have been inferred in one case could be used in another if it fits within the rules of evidence. And those are all circumstance based when we get to it. It depends on what the evidence is showing and what the record has shown up to that point, and whether the court deems it to be admissible or not. And every time I admit issues, I always cite the statutes so that it can be viewed later, and so that they know that we're just not guessing up here. I help the Court of Appeals understand why I make decisions that might be appealed. But anyway, that's all of that are issues that will be addressed, and I will point out on the record why I make my decisions and what I'm using under the law to support my findings. Yeah, that's the way I do. That's why that's why we have very few. We've only had 2 or 3 reversals here in 16 years. And it's because I'm very sensitive about making sure that it's done right. What a jury decides and how they deliberate, it's their business, but we don't try to influence them. We just make sure that the law is correct and correctly applied. That's a judge's, that's what the judge's responsibility is. And then you get to make it's your life, and you get to make important decisions on how your life, what direction is going to head in by your decisions you make. And once again, I have, as a United States attorney, as a defense lawyer, as a prosecutor, as a judge, people representing themselves in city court or JP courts, Class C misdemeanors, they can do okay. They can do well. They get a chance to be heard, and the rules of evidence are really not as tightly used. So it's kind of like a people's court kind of thing. But here in felony court, the most serious types of crimes, it's people who represent themselves. If they're not trained and experienced, they're at a disadvantage. And that's why I urge you to, I know you might, well, don't laugh at me. I'm just telling you what has been 43 years of experience, longer than I think you've been alive. But I've seldom seen anybody represent themselves well and effectively. And I've seen a lot of it. But the law says you can make that choice as long as you do it voluntarily and you understand the consequences that you're facing. Most people just seem to that have problems with that for whatever reason. Generally, it seems to be that there's just they are not confident in the lawyer that's been appointed to represent. So that generally is what causes that. But a lawyer, I mean, you didn't go to law school and you hadn't been trying cases in front of courts and juries, and that's like anything else, whether it's sports or a career, you're at a disadvantage for somebody who has experience in it. And that's why this is your life. And when you're looking at life imprisonment, you have you ought to use all the help that is available so that you can shoot your best shot. But you make the decisions, but a lawyer who is deemed competent by law is going to be close by to assist you if you ever if you need and change your mind. Because I've had them do that in the past too. They start off and then it doesn't take long. But then about 3 or 4 months ago, a guy represented himself in a case.
I understand that why you might feel the way you
Well,
feel.
it's the way the law states it is. That's the way I feel. Because the law states that you always have a right to change your mind. And if you do, it's not wise to stop the trial and try to find a lawyer. That's why a lawyer is going to be here in the courtroom. And you can sit by yourself, and you can even have them sitting with you if you want, but they'll be there if you need to refer to them in any way. So,
Your Honor,
anything else?
the 1108, I've been trying to consistently apply that or whatnot, and they refuse to do it. Is it
What are you talking about?
the 1108 habeas corpus felony and indictment?
Say that again.
Felony and indictment and indictment felony that I don't know.
You don't know.
That's how it's said. I don't know no other way to. It's felony and indictment 1108 habeas corpus.
What are you asking?
I've been trying to apply that and they keep refusing.
Who's they?
The clerk. And I was.
What are you asking to do? What relief are you asking for?
The relief on India Rito.
What?
The India Rito?
That's one of the other sexual assault charges.
Yeah. I was trying to apply my habeas corpus for that in this district court, but they refused to submit it and file it. And I've been desperate.
Well,
to get
what are you wanting? What are you wanting done?
to permit that habeas corpus.
What do you mean habeas corpus? What are you wanting done?
So her statement and her allegations from day one is said she never accused me, nor did she say she recognized anything that describes me in any type of form or fashion. You know, you see what I'm saying?
No.
And he Charles Duchamp literally charged me with that for absolutely no reason.
Okay. You will have your opportunity to bring that up
Well, that's what
during a trial.
Is it possible you can get them to by as the law provides?
What is it that you're saying the law provides that you need addressed?
After the person is indicted, the person can make a habeas corpus application, or well, not petition, and turn it in, submit it to the district court that indicted the person or whatnot.
For what relief are you asking for?
Or
What
to
is
get
it for?
dismissed.
Okay. It has been indicted by a lawfully impaneled grand jury, and we will hear it at trial, and you will be able to test the credibility of the allegations. But those are things that are done in every trial. Every trial that a defendant says, I am not guilty, then that is brought before the jury and tested under the rules of evidence. And then the jury decides whether the allegations have been proven beyond a reasonable doubt or not.
Well,
And that's what we are going to do.
well,
It's moving to a jury trial, and a jury will be testing what you're telling me or issues about. And those are issues that are alleged in every trial, that the complainant, when they plead not guilty, the complainant credibility is questioned because it's the complainant says alleges one thing, and then the defendant says that's negative, that's not true, And that's why we have a jury to listen to the presentation from both sides and then be the arbiter. Now, I'm not the arbiter on a question of fact. If the case is not before me, you've asked for a jury trial, they will question the facts, decide what the facts show, and they will make the decision.
I was just wondering if I can exercise my rights under the habeas corpus. And
Habeas
Yes.
corpus is a right all people have, but what you're articulating to me is you want a hearing to address fact issues that are part of the allegations that are in the responsibility and domain of a jury. Not, and you haven't gone to me for trial. So you're going to a jury, and that's what a jury decides in every case, whether the allegations are true or not.
so that means I would not be able to exercise my rights under that.
If you apply in the correct way, you can do that, and I'll make a ruling on it. But you've asked for a trial, and we don't dispose of cases by
This is a whole.
anything else you want to interrupt me on?
Oh, no, go ahead.
Okay, because she's got to take all this down, and she can't take things down when two people are speaking.
Excuse me.
What else do you want to say?
The case that we're going to trial for is completely different than the one I'm asking for the habeas corpus for.
We're going to trial on that, and if after that trial, then we'll take up any other matters that you want next, but one thing at a time.
So it's not possible you order the clerk to submit that.
No, I don't have anything before me that I've seen in writing, but when it does, if
I actually
then
got it right here.
I'll do it, file it correctly, and then I'll do it.
She won't file it. That's what I'm asking. To get her to order her to, because it's.
Why
it's
didn't you
written.
want to do that?
Because she said y'all don't do it. She said this court don't file 1108, just 1107. And, you know, that's a direct violation of my right.
You just send it to the you have the mail in the jail, right?
The mail in the jail.
You can submit mail in the jail, right?
Send mail, yeah.
All right. Send it to me. And I'll put it in the file, and it's in the file.
I tried that, they will not at all. They won't submit it, period.
Make a copy of that and give it to her. We'll make a copy of it, and we'll just put it down there. We'll make a copy and get that back to you, and we'll keep a copy. I'll put it in the file. And that's all I'm gonna do. I'll read it. I'll read it and see if there's anything that changes my mind, but no, we move forward on an indictment, and I haven't heard anything that questions the allegations in the indictment to allow a hearing on the credibility. That's what trials are for. That's why they invented trials.
Well, the indictment
That's
doesn't
all.
match.
It's not a debate.
Affidavit.
Just make a copy of it, and we'll make a copy of it and get that back to you. I'll look at it and see if I change my mind.
I was just hoping you would, you know, let me exercise my rights under the habeas corpus.
I'll make a copy. We'll make a copy of it. Okay, and then I'll look at it and get it back the original. Okay.
That's all right. I was just hoping you would actually
All
follow
right.
the way.
That's all. That's all I can do is I'll make a copy, review it, and then decide. Okay. All right. Anything else, Mr. Peoples?
Other than my paperwork from
I'll work on that. We'll work on that today. That is all. Thank you. Anything else from the party?